Hello friends, welcome to our lecture series on corporate social responsibility. This is Aditya P. Tripathi. I am once again here with you to continue our discussion on the topic of CSR. This is going to be part 3 of our lecture series on CSR, and in today's lecture I shall be discussing with you about legal framework of CSR in India. In previous lecture of mine I told you about the global scenario of CSR, what exactly CSR is all about, and we also tried to have a better understanding of different definitions of CSR, its meaning, its relevance, importance, and many other aspects of CSR were discussed in the initial 2 lectures of ours. And keeping in mind the scenario of CSR in India, I just thought that we should first understand what is the legal framework of CSR in India, and getting aligned with that, we have planned our lecture of today in a manner that we will be starting with our discussion. We will be starting our discussion with the CSR in India, its legal framework, applicability of CSR provisions, CSR expenditure, what is the maximum and minimum limit for that, what is the sequence of amendments in law, scope of CSR expenditure. So these are the broad contours of CSR which we are going to discuss today. So what is CSR in India? What is the legal framework of CSR in India? In India, we have got a proper mandate for expenditure on CSR. India has legislated CSR spending as a mandatory requirement under law. And if we talk about CSR legislation or legal framework of CSR in India, it has 2 folds or 2 aspects. One is that companies have to undertake business activities responsibly so that there is no harm to the society, and the other is that the company have to go out and spend funds annually for the welfare of the society. So these are 2 important aspects of CSR in India, that they have to undertake business activities in a responsible manner, keeping in mind that there is no harm to the society at large, and secondly they have to go out and spend some amount of funds, which is basically 2% of their profits on listed activities or identified activities, and that is basically targeted towards the welfare of the society. And there were no penal provisions on non-spending till January 2021, but and it was merely a provision of comply or explain. If you are not able to comply with those provisions, you have to explain what is the reason behind that. But now there is a penal provision also into that. So with this very basic idea about the CSR provision in India, or the status of CSR in India, let us talk about legal framework of CSR in India. So whenever we talk about CSR provisions in India, we are reminded of Companies Act 2013, and within the Companies Act 2013 we are reminded of section 135 of that particular enactment. So if somebody is talking about CSR provision in India, section 135 is basically the address to that. This is a section where in Companies Act we have all the legal provisions mentioned in Companies Act 2013, and when we talk about section 135, it has to be clubbed with Companies Corporate Social Responsibility Rules 2014, which was published wide notification number GSR 129E on 27th of February 2014. So when we talk about legal framework of CSR in India, we have to remember, my dear learners, that section 135 of Companies Act is basically the section where the provisions are mentioned. But apart from that, we need to remember the company's rules, Companies CSR Rules 2014, which was notified on 27th of February 2014. The CSR provisions are basically governed under section 135 of the Companies Act 2013. So you need to remember this specific section of Companies Act 2013, that there is a section 135 which deals with the with this very topic of corporate social responsibility. What is there into that enactment? That is basically the point of our discussion of today's lecture. I shall be telling you all the relevant provisions, what are the different aspects of section 135, what are those activities where companies are supposed to spend. So those prescriptive or prescribed activities on which you have to spend, and they basically amount for or account for CSR. And remember, when we talk about section 135 of Companies Act 2013, it has to be read with the Companies CSR Rules 2014 and Schedule 7 thereto. So when we study section 135 in a very obvious manner, we have to look at CSR Rules 2014 along with Schedule 7 of Companies Act 2013. So I'll be telling you not only section 135 provisions of section 135 but also CSR rules 2014 along with schedule 7 of Companies Act. So let us first talk about applicability of section 135 of Companies Act 2013. There is a very basic question that which company is supposed to spend on CSR? Is it compulsory for all? Is it mandatory for all companies operating in India, or there are certain riders or certain restrictions or conditions upon which we have to decide that whether this company is supposed to spend some amount on CSR or not. So for that we need to understand that no, it is not compulsory or mandatory for all companies, and when we have to decide that whether my company is for my company spending 2% of my profits is mandatory or not. So I'll have to look at the stipulated provisions, the conditions, and if my company company fulfills those conditions, then of course I need to spend, I need to comply. So as per the financials of immediately preceding financial year, if my turnover is rupees 1000 crore or more, suppose I am operating as a company in India and the turnover of my company is rupees 1000 crore or more. So this is the first condition. Either this I am fulfilling, or suppose if my turnover is not rupees 1000 crore or more, but my net worth is rupees 500 crore or more. My company's net worth is rupees 500 crore or more. Then too I'm supposed to think, or I'm supposed to be prepared that I'm falling in this specific segment and I need to spend on listed CSR activities. So first condition was turnover of rupees 1000 crore or more, or suppose if my net worth, my company's net worth is rupees 500 crore or more, or there is another condition that if the profit of my company exceeds rupees 5 crore, either it is rupees 5 crore or more than that. So even if my profit is rupees 5 crore, then too these provisions of section 135 are applicable for my company. So remember, my dear learner, these are three important benchmarks which we need to remember. That first of all, I need to check my turnover, whether it has crossed, whether it is reaching 1000 crore, it has reached to the level of 1000 crore or more than that. If it is so, I need to stay alert. Or if my net worth is rupees 500 crore or more, or my profit is rupees 5 crore or more. So these three important values or figures we need to remember while reading this specific provisions of section 135 of Companies Act 2013. If any of these three are applicable to my company, if any of these three is applicable to my company, I am supposed to be ready, to be prepared for this provision of section 135 of Companies Act 2013 related to CSR. And in that case, what I need to do, there is a provision under section 135 subsection 1. The provision is that such companies are required to spend a minimum of 2% of their net profit over the preceding 3 years as CSR. So if I am fulfilling any of these three conditions which I have discussed just now, my company is supposed to spend 2% of its net profit over the preceding 3 years as CSR. So which profit? I'll be telling you how to calculate that average net profit of preceding 3 years and how do we decide the amount to be spent on CSR. And remember, my dear learners, that 2% of our net profit over the preceding 3 years we have to spend on listed or identified activities. There are certain exclusions also into those provisions which I'll be telling you in our discussion, which I'm going to discuss with you today. I'll be basically telling you all those important provisions, important sections of CSR, so that you have a better understanding of this provision of CSR, the legal framework of CSR in India. Normally, whenever we ask a learner that what is the provision of CSR in India, they basically come up with an answer that, sir, it is 2% of company's net profit. So you need to understand that 2% is not mandatory for all companies operating in India. If your company is fulfilling any of these three conditions which are prescribed there, then of course you have to spend on listed CSR activities, the prescriptive CSR activities, which I'll be telling you in due course of our discussion. So this is basically section 135(1) of Companies Act 2013, which prescribes that if your company is fulfilling any of these three conditions, then of course you are supposed to comply with the provisions of section 135(1), that is spending 2% of your net profit on CSR activities. Now the second very pertinent question comes to your mind. that said what should be the quantum of CSR expenditure. Is there any maximum limit or minimum limit? Whether I am supposed to spend 2% of my profit only, or may I spend more than that, and what if I spend less than that? So remember, my dear learners, whenever we read any legal provision, we have to be very specific to the selection of words, to the statement which is stipulated within that specific section or within that specific provision. So if you look at the CSR expenditure provisions, there is no maximum limit for that, but minimum is 2% of your average net profit of preceding 3 years of profit. So suppose if in present year, in year 2023, suppose you are fulfilling any of those 3 conditions, either your turnover or your profit or your net worth, if you are fulfilling any of those 3 conditions, then of course you have to spend a minimum of 2%. Remember, this section is not prescribing the maximum limit. So maximum is, the limit is with you, there is no limit, it is completely at the discretion of the company. If you feel like spending more than that, there is no restriction on that. There are a number of companies in India who have been spending prior to this enactment, and today also they are spending more than the minimum limit, more than the stipulated limit of 2% of their average net profit of preceding 3 years. So they are basically spending more than that. So the minimum is 2%. And if we, for your convenience, I have taken the extract from the provision which says that the board of every company referred to in subsection 1 of section 135 shall ensure that the company spends in every financial year at least 2%. So when there is a prefix of at least 2%, it prescribes a minimum of 2%. So maximum, there is no limit, there is no restriction. You can spend greater than that if your company feels like spending more amount on listed CSR activity, then there is no restriction, there is no control over that, there is no prohibition under this section 135 of Companies Act. So enactment is not prohibiting you to spend more than that, but minimum is 2%. So if you are fulfilling any of these 3 conditions, you have to spend a minimum of 2%. So remember, it is a minimum of 2% or at least 2% you have to spend on listed CSR activity. Now, when we talk about applicability of CSR provisions on different types of companies at a glance, deliberately I have kept a section of frequently asked questions on CSR, which even Ministry of Corporate Affairs have published on their website, so that people should not have any confusion, because this enactment is basically undergoing so many amendments. So at times we have some doubt as a stakeholder. So for the convenience of stakeholders, Companies Act basically stipulates this as a provision that there are certain FAQs, and for that they have given specific answers. That also I shall be discussing here. So, but there are certain questions, certain popular questions are there which I thought that we should know. Suppose if we ask about a public company, yes, if your company is satisfying any of the criteria, you have to spend. This CSR provision is applicable on your company. If you are a private company, answer is yes. Section 8 company is basically the company which is working for not-for-profit organizations, for social causes, NGOs, and any company which is working on a no profit no loss basis. The companies which are not working for profit making, like educational institutions, research institutions. So they belong to this category of Section 8 companies. And at times students think that for Section 8 companies, of course this provision might not have been applicable, it should not be applicable, but answer is different. It is yes, it shall apply if your company is fulfilling any of the 3 criteria mentioned under section 135. So you have to remember, even Section 8 companies supposed to comply with the provisions of section 135. For them also these provisions of CSR are applicable. Deemed public company, there is also a category of deemed public company which is bearing certain characteristics of a public company, but essentially it's a private company. For them also it will be applicable if the company is satisfying any of the criteria. Foreign companies, of course, for them also it is applicable. The provisions of section 135 is applicable to foreign companies operating in India if they are working in India, and they have to abide by the provisions of section of Companies Act 2013. Then of course section 135 cannot be an exception to that. They are also supposed to comply with the provisions of section 135. Now, after understanding the category of public company, private company, foreign company, deemed public company, section 8 companies, there is another question: what if my company is going in the process of liquidation? So if the liquidation process have started, then whether my company is supposed to spend on CSR or not? So answer is very clear: since the company is under liquidation, there are no profits. Company has initiated the process of liquidation, which means the binding up process has started, and there is no profit. And since there is no profit, of course, no CSR expenditure is required. So this is a situation where your company under liquidation is not supposed to spend on CSR because already there is no profit. And if there is no profit, then of course the provision of section 135 cannot be implemented, or it cannot be applicable for your company. Another segment is companies which has not yet completed 3 years. What if my company is new, and in the very first year my turnover or my net worth or my profit is very much as per the provisions laid down under section 135? Then of course, yes, these provisions are applicable to us. Then another question comes to our mind: how to get, from where to get profits of preceding 3 years? Then in that case, of course, will not search for preceding 3 years profit. Whatever is the profit of the previous year, the preceding year, that shall be taken into consideration for the purpose of calculation of 2% of the profit provision, that you have to take up the profit which is available. We will not wait for 3 years to complete and then we will spend. No, the provisions are applicable even for new companies. So the crux of the story is that if your company is new and it fulfills any of those 3 conditions laid down under section 135 subsection 1 of Companies Act 2013, then of course they will have to spend 2% of their profit on CSR activities. So these were some important questions which we come across, and students who are learners who are dealing with the topic of CSR, they basically ask this question to us. So I just thought that I should clarify it here categorically. You should know what about foreign company, what about public company, private company, section 8 company, deemed public company, companies under liquidation, and companies which are new and it is their very first year and they are fulfilling those conditions. So how to decide whether they are supposed to spend on CSR or not? And whatever I am telling you here is basically from the mandate, that is provisions of Companies Act 2013. So coming to the sequence of amendments in CSR provisions in India, that how many amendments have taken place till date, that we should know, because year after year we have witnessed different amendments according to the requirement. And since the provision of CSR is very evolving and very unique in nature, that is why it requires certain amendments, and depending upon the feedback of different stakeholders, Ministry of Corporate Affairs have been very actively working on making the CSR provisions a complete setup, a complete provision, complete enactment, a perfect enactment where there is no doubt, there is no confusion to any of the stakeholders. So first amendment, it took place in the year 2017, Companies Amendment Act 2017, which was notified on 3rd of January 2018. Second amendment was Companies Amendment Act 2019 after 2 years of the first amendment, and it was notified on 31st July 2000. It was basically it proposed on 31st July 2019 and notified on 22nd of January 2021. And in this amendment is very important because it introduced section 135 subsection 7, which is basically a shift from comply or explain to comply or pay fine. Before this amendment of 2021, companies were supposed to comply with the provisions of section 135 subsection 1, and if somehow they were not able to spend 2% of their profits on listed CSR activities, they were supposed to only explain The reason, there was no penal provision, there was no fine for that. But after this amendment, the provisions related to payment of fine, it got introduced. So financial, when we talk about payment of fine, of course it is a financial, it has a financial implication. When I will be telling you how to calculate the amount of profit which we are supposed to spend on CSR, there we will have a discussion on this payment of this provision related to comply or explain and comply or pay fine. What is the implication of that we shall discuss. Third amendment, it came in the year 2020, which was basically a very significant year in the history of the entire world, when we braved the brutal pandemic of COVID-19. So Companies Amendment Act 2020, it was basically notified on 22nd of January 2021, and it was basically proposed on 28th of September 2020, and it substituted section 135 subsection 7, and it is again a shift from comply or pay fine to the comply or pay penalty. So that also we'll discuss when we'll have a discussion on the penal provisions. So this was another important milestone in the journey of enactment on CSR. The fourth amendment, Company CSR Policy Amendment Rules 2021, it was notified on 22nd January 2021, and the latest one is Companies CSR Policy Amendment Rules 2022, which is notified by Ministry of Corporate Affairs on 20th of September 2022. So this is a sequence of amendments and CSR provisions in India, which basically speaks about the kind of dynamism we are having in this specific enactment, that is provisions related to CSR, and it indicates, there is a reflection that ministry is very much serious about, the government is very much serious about the provisions of CSR, and of course whenever we have this kind of enactment and we move ahead, we find certain requirements of certain changes which are supposed to be incorporated into the given provisions, and these amendments are basically the answer to those questions, those points. That it is just like, we are updating our course curriculum, we have to update our syllabus in order to make it market friendly according to the requirement of the present corporate entities, the present job scenario. We need to stay updated, we need to stay relevant in the marketplace. When we are going through a specific course curriculum or syllabi, we keep on revising. Likewise, these provisions require certain revisions, and these amendments are nothing but the revisions into the given provision. So this was basically just to tell you the number of amendments which have taken place, which have been made to the provisions of section 135, or you can say Companies Act 2031, section 135. Whatever changes have been made, this is a sequence of those amendments. Now, when we talk about scope of CSR expenditure, we need to understand that from where to get the scope of CSR expenditure, where it is mentioned. So definition of CSR in Rule 2 subsection 1 D seeks to exclude several items from CSR spending. The exclusion, knowing exclusion is equally important. Apart from knowing the list, knowing the prescriptive list, that these are the areas where we are supposed to spend some amount on CSR. So basically there are certain exclusions also. Previous definition explained what CSR includes, that is by reference to Schedule 7, but revised definition has a list of exclusion also. Initially we got Schedule 7, and it has a dozen of listed activities. Total 12 activities are there. Still they are there, to a number of activities on which we may spend on CSR. Under Schedule 7 it is 12, but revised definition has a list of exclusion. At that time, initially there was no exclusion, there was no list of exclusion, but now we have a list of exclusion, that these are the activities, and if your company is spending on those activities which fall in the list of excluded activities, then of course that will not be counted for your 2% profit expenditure on 2% of profit which is being spent on CSR. So knowing those exclusions is equally important. Further, the expression statutory obligation is notable in that provision. 6 exclusions are specified in rules, which I'm going to discuss in today's lecture. And in any case, Schedule 7 still remains a list of activities or subject on which we may spend we may plan our expenditure of 2% of profit on CSR. So let us have a discussion on exclusions first, then I'll show you the list. First of all, the first very activity is that activities undertaken in pursuance of normal business of the company. If your company is making some expenditure in normal course of your business operations, then of course that will not be accounted for the CSR expenditure. Because you are basically working as this activity is basically it belongs to your company, it belongs to your normal business operations. So of course it is not going to be included under those 2% expenditure on CSR. But my dear learner, here I would like to clarify that there is a specific exception to this provision. During this pandemic of COVID-19, some pharmaceutical companies, they were donating medicines. They were basically distributing free medicines or other equipments to the needy people, to the general public, and that was very much into the normal course of those companies. That was a normal business of the company, selling medicines, giving medicines. But since it was not for profit, it is supposed to be excluded from the list of expenditure, which is basically allowed under 2% of profit being spent on CSR. So this was the first activity, but there is an exception to that. Activities outside India is also excluded, except training of sports personnel. If some sports personnel, they are getting training outside India, that is allowed. Otherwise, any activity outside India is excluded from the list. Contribution, either direct or indirect, to a political party is not going to be allowed. Activities causing benefits to employees, if you are doing any activity which is for the benefit of your employees, of course that's your routine activity and it is excluded from the prescribed list of activities on which you may spend, and that would be accounted for as CSR expenditure. Sponsorship for deriving marketing benefits for products or services, that will also not be allowed. And activities for statutory obligations, of course it's your obligation, it's a statutory obligation, so it will not be accounted for this. So with this, I am ending this very lecture of mine. I hope you must have understood the legal framework of CSR in India. See you soon with another lecture on CSR. Thank you so much.